Hi, my name is Lisa Uresti, and I'm an attorney, and I practice probate, elder law, and estate planning. But today I'm here to give you a few tips so that you can protect your assets. I'm going to assume that you do not have an estate plan. And when I say estate plan, some people are going to be, oh, I don't need an estate plan. I don't have a lot of money, or I don't have millions of dollars, or I'm not rich. But an estate plan is not just for people who are wealthy. It is for people who have a home, who have a car, who have money in the bank, who have a retirement, or who have children. 70% of Americans do not have any type of estate plan. That means they don't have a will. They don't have power of attorney. They don't have a trust. They may not even have the correct beneficiaries listed on their accounts. I'm here to tell you some things that you need to know. So first of all, you need an estate plan, whether that's a will or a trust or even a ladybird deed or some other document that helps you protect your assets. Because we all work so hard. We work to buy a house and to buy a car and to save money, but you need to protect your assets. So when you die, you don't have family fighting over it, or somebody from the county or the state isn't able to just take your house. First of all, I'm going to talk about wills. A will is just a piece of paper that says, I give this house to my cousin Sarah, or I give my bank account to my cousin Joe. It just distributes your assets when you die. However, one thing you need to know that some lawyers won't tell you is that you only have 4 years to probate your will in the state of Texas. A will must go through probate. What does that mean? Well, it means that you have to go in front of a judge. The judge has to say, yes, this is a valid will. Did it have witnesses? Were the witnesses disinterested? Did you sign it in front of the witnesses? Was the will notarized? Was it dated? Were the witnesses over a certain age? All of those things are necessary to have a valid will. Even if you just write a will and sign it, and some people think that's enough, if you didn't have witnesses, it may not be enough. Probate is when the judge says, yes, this is a good will. Yes, you have an executor. Yes, you can distribute the funds of the person who died. And the control lies within the judge, because a judge could say, no, it's not a valid will, or no, you cannot be the executor. It sometimes gets very expensive. So first of all, you pay for a will. Most attorneys will probably charge over $1,000 to do a will, maybe more depending on how expensive it is. But then when you die, your family has to hire an attorney to probate your will. Again, most attorneys are going to charge you over $3,000 to probate a will. Maybe over $4,000. Then there's filing fees that could cost $500 or $1,000. It just really depends. But now you could have spent over $5,000 or $6,000 to do your will. Going through probate takes time. You have to go in front of a judge. You have to get an order that says that it can be probated. You have to get letters of testamentary. And you can still have fighting. If you have 3 kids and you didn't give some of your assets, they could fight. Or if you distributed your assets equally, they could still fight. They could hold up the sale of the house. One may not pay the taxes. So there are a lot of issues that you need to think about before you decide to execute a will. Understand that you need to do something, because if you don't, your house may sit there after you die and may never get sold, and you may owe taxes, and the county may take your house. Here's something else. I will tell you about a trust. Okay, what is a trust? Well, a trust I call a basket method. A basket is this little basket, right? And it has a little top. You can put things in, you can take things out. And so you can put stuff in the trust whenever you want, or you can take it out of the trust whenever you want. You're able to have a little more control. You can have if my child goes to college, I will give them $5,000. Or if my sister takes care of my kids, she can have my house. If this, then that. If you're like me and you want control, a trust might be the right option for you. The other thing is that a trust can help you sell your house very quickly to where you do not need to wait to probate. If you do a trust correctly and it's funded, then you may never have to go in front of a judge, and you won't have to pay an attorney to go and probate your will. You may never even have to step foot in an attorney's office when someone dies. The other thing about a trust is that it can protect your beneficiaries. So if you have 3 children and one is a minor, well, in the state of Texas, a minor cannot own a home. But if you have a trust and you say what should happen to the trust, even if there's a minor, or what happens to the minor share, then you can still sell the house, even if you have a minor. If you have a child with a disability and that child receives government benefits, you do not want that child to get a big asset. So you don't want that child to get a house or $100,000 because they could lose their disability benefit. That is something a lot of people don't know. If you have a trust We can shelter and shield that money so that it's not counted. Those are two things that we can help you with. We do wills, we do trust. Some people say they want a will, or some people will want a trust. There's no right or wrong answer. Really, what it comes down to is how much control do you want? Are you willing to put in the work that's needed for a trust? Because sometimes it's a little more work. How much protection do you want? Do you have a kid with a disability? Do you have a minor child? Are your assets going to be fairly easy to distribute? Do you have one child and one house? So maybe we do a will with a ladybird deed. There are so many options, but one thing you need to know is you have to take care of your assets and you have to protect them. And I will advise you to see an attorney and see someone who does wills and who does trusts and other estate planning that has your best interest at stake and at heart. Because the key point to all of this is you can protect yourself, you can protect your family, and you can protect your life saving. So if you have any questions and you want to talk with us or you want to have a consultation, feel free to call us. Our number will be up at the end, but it is 210-914-8493. You can visit us on our website at www.urestilegal.com. And again, my name's Lisa, and thank you for watching. Have a good day.